made.
Guess names.
Change that clock. I got to change that clock.
Clock's slow.
Tonight's meeting is called to order. We can stand and say the pledge to the United States flag. Pledge allegiance to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
It's about 7:30.
Tonight, I'll open up the table to the council that's called this meeting.
I don't see our attorney here, so did someone bring the notice with them?
Resolution?
The notice?
Yeah.
Could you read it, please?
Yes. Is he close? Wait, is he close? Is he? Check him right now. It's hard to check. I mean, he wrote it, so I can read it.
Just read the meeting notice if you would, please.
County of Grant, City of Crittenden, resolution number, it's
Oh,
blank.
I'm sorry, not the resolution, the meeting notice. The meeting notice, I'm sorry, this thing I can't talk to, just to show why we're here. This is a special meeting, so people will know.
It's hard to hear you all too, since we don't have microphones.
You got the action notes? Thank you. I have the action, okay. So, request for special city council meeting. The following Crittenden City Council members, by affixing the signatures below, constituting a majority of Crittenden City Council pursuant to KRS 83A.130, parentheses 11, are requesting a special meeting to be held at 6:30 p.m. Tuesday, November 17th, 2020, at the Crittenden City Building to discuss the following agenda items. Issuance of charges of misconduct and scheduling a public hearing pursuant to KRS 83A.040, parentheses 9, for the removal of the mayor. That pursuant to KRS 83A.130, parentheses 11, the city clerk is directed pursuant to law provided applicable notice of said special meeting, which is up 24 hours in advance.
Okay,
And
thank
to the
you.
paper. Yeah.
And we've now begun, Mr. Volker, our attorney for the council. The purpose, of course, as he just read, is to present a resolution. And if you'd like, I could read the resolution. Can everybody hear me? No, I don't think so. Can you hear me without this thing?
Can I turn this on?
Okay. I can speak louder without this, Andy, that's all right. If you can't hear me, hold up your hand. This is a resolution issuing charges of misconduct and setting a public hearing pursuant to KRS 83A.040, subsection 9. Whereas KRS 83A.0409 sets forth applicable provisions of law for the removal of any elected officer for misconduct, incapacity, or willful neglect, and whereas KRS 83A.047.9 provides that a public hearing shall be conducted with due deliberation and creation of a record for any removal hearing, and whereas while not set forth in KRS 83A.047.9, the proffering of charges to be considered regarding applicable facts for which removal is sought, it is the intention of the Crittenden City Council to present Mayor Camilla K. Patton notice of charges to be considered at a public hearing where the Crittenden City Council will consider her removal from office pursuant to 83A.047.9. Now therefore, it is resolved by the Crittenden City Council as follows. That pursuant to KRS 83A.047.9, the Crittenden City Council by this resolution adopts and sets forth the following charges of misconduct against Mayor Camilla K. Patton. 1. Did Mayor Camilla Patton appoint herself to an incompatible office pursuant to KRS 61.080, and in so doing vacate the office of mayor pursuant to 61.090? 2. Did Mayor Patton violate KRS 83A070 and Crittenden Code of Ordinances Section 20.06 by paying herself compensation required to be fixed by ordinance, in which she paid herself in excess of the approved amount of salary for mayor, KRS 83A070 sub 1, and/or paid herself as the ABC officer without authorization by duly enacted pay classification plan pursuant to KRS 83A070 sub 2. Did Mayor Patton's provision of services as the ABC officer and subsequent additional payment constitute a provision of service pursuant to KRS 61.251, and if so, were Mayor Patton's payments for additional services in violation of KRS 61.252 sub 2, specifically stating that violation of this section shall be grounds for removal from office or employment. Furthermore, that these charges of misconduct shall come on for hearing on Thursday, November the 19th, 2020, at 8:00 p.m., and the Crittenden City Clerk shall cause this resolution and notice of hearing to be served upon Mayor Camilla K. Patton, and provide certification to the council of said service. Introduced and adopted this the 17th day of November 2020 by the council of the city of Crittenden, with the following council members voting as follows. So we need a motion to adopt this resolution.
I'll make a motion.
Second to that motion.
I'm going to discuss from a legal perspective. I'm still the attorney.
Second to that motion.
I'll second the motion.
I need to
The
have.
motion having now been made and
So-
seconded, the floor is open for discussion.
Thank you. So I have some concerns about, there's lots of concerns, of course, but the big issue is the due process given to the mayor for purposes of having a hearing in 2 days. I think if all of you were in the same position, you want longer than 2 days in a COVID-filled environment to hire a lawyer, meet with them, pay them, retain them, study all the documentation, be prepared. It's illogical to suggest that a situation as important as this, not only for the city of Crittenden, but has statewide implications, that you would have a hearing in, frankly, 48 hours and 49 and a half hours. So my advice is, at least from many constitutional protections, both federal and state, is that I think that there are major concerns with moving forward on that hearing on Thursday. I do not represent Kate personally. I have no idea if she's going to retain a lawyer or not. It's up to her to decide. My goal is to continue to give advice to council. I do have significant experience in federal court. I anticipate that if there is a challenge pursuant to some of the case law that I reviewed last night, when the insinuation was that this was coming, is that there's very little case law, but there's one that's very poignant. It's a federal case, and it simply says that the due process has to be given. It's terribly important. I understand you all have the authority, and you should if you decide to move forward, but 2 days is not reasonable. And if anybody here was in that position, again, they would want longer than 2 days to prepare themselves. That's my point. Thank you.
I run that through, the statute does not prescribe a time frame. It just says, public hearing. It doesn't, for example, in zoning, it's very specific. You may have to give no less than 7, no more than 21 days notice. This one is silent. I think that the initial discussion that some of the council persons that reached out to me, there was a thought of having it a week later. But I think the issue, and I don't think Alex would know this, is that there's been some, I'll use the term threats from what I've seen, brought against council members by third parties. I believe that apparently there was went to one council member's house last night that resulted in the sheriff's having to be called. So that was why it got changed to move it up, because, and one thing I would tell you all is, tonight, you don't discuss the evidence, because as Alex is alluding to with due process, the hearing has to be the hearing that day. You don't take on evidence outside of this, just
Turn
like.
right on Southern Court.
Tell me.
Turn left on Dixie Highway.
But the key is you do not want to deliberate or do anything outside of this. That also goes that you should not, people in the public should not be contacting you, telling you to do something one way or another. That should all be brought out at a public hearing. That is fundamental to due process. Due process is the right to have the charges or whatever presented against you and the right to a meaningful hearing.
Acting as counsel's attorney, do you believe that 2 days, less than 50 hours is enough time to prepare for removal when they've still been trying to get a judge removed for 1.5 years? Do you think that that is due process?
A judge, I think that it's,
Okay, I mean, it's just a yes or no.
I think the question is, I think if that question is raised and there's time needed, I think that's a request that the mayor would make to the city council
I'm worried about getting sued, because right now, that's the role that I'm in. So I'm looking at it as an aggregate, the city gets sued, it's an 83 action, they're gonna pay the fees of whoever she hires. It's not us, it's not you, it's not me.
Alec, the problem is, you say you're not advocating for her, you're not her attorney, but you do appear to be. I think the statute says a public hearing. I don't think any of these issues are unknown. I think that they are pretty well defined. I think council a week or two ago drafted a resolution. I think that you had a letter from a special prosecutor talking about incompatible offices. I don't think there's anything that's been hidden or not known.
The other thing is there's an attorney general that, of course, is investigating the matter, who's going to render an opinion that's on point with all the issues that you've raised. It would seem to me the most judicious way is to allow the attorney general to make a finding, which is appealed directly to the circuit court, because this is where that's headed anyway, without any expense. And then what happens is the circuit court is going to make a decision, or the federal court.
It's not the way the attorney general opinions work. They're just advisory in nature.
You have an option, right? Once the attorney general has issued an opinion, to seek other remedies.
The attorney general's office that I spoke to
On
asked the question
on behalf of the city, as an authorized representative of the city?
after I was hired by this council and asked to communicate with the
I
attorney
just want to
general's
make
office.
sure it's in that capacity as council.
And yeah, obviously I would have no reason to call the AG about the city of Crittenden.
Understood.
I honestly had no idea what was going on in Crittenden. I don't live that close to here, obviously, as the traffic today showed. The question was posed is, you know, there's the power of the AG, which would be an ouster action pursuant to more or less along the incompatible office. But as to KRS 61242, that would be something that council could decide. So I don't think there's I think the Attorney General certainly has authority if they want to do something. And I think this body certainly has authority to do something. And again, no one's saying that's going to happen. It's a hearing. You have a hearing, you take on evidence, you develop a record, and then at that point in time, the 6 council members would need to decide their vote.
Okay. Having heard statements now, does council have any questions concerning this matter? Anyone on council? What process is considered due? What are you asking?
I would defer to, excuse me guys, I'm sorry, I had a COVID test today, it was negative. So I had to make sure, yeah, that's always a good place to start. But I would defer to the person that's the accused, the person that's going to be seeking opportunity to defend
Please, allow her
themselves.
to speak.
So,
Okay,
I
what
think that's her
process do you
issue.
believe is due?
I'd like for you guys to give me time to get my attorney here. you
Give us a
know.
date, give us time. What time are you saying?
Do you want to meet on Thanksgiving week? Do you want to meet after Thanksgiving week?
We're asking you for time. What time do you think is due?
November 30th at 7 p.m. It's a Monday.
What's council say? It has to be a joint decision?
What's the date?
She's saying November 30th.
That Monday after Thanksgiving, I think, that Monday.
it's entirely possible she does retain it, they're going to, whoever's going to ask for additional time to study the merits of the case. But be that as it may, you guys got to do what you got to do.
Yes, well, that isn't decided yet. We're simply trying to see, does council have anything to say concerning the timing? Do you wish to go ahead in the 2 days? One of the statements made was the Section 1983 action acting under color of state law. Honestly, I can't see anything like that taking place. I see, if anything, an appeal of this decision, should this decision be rendered against the mayor, and that would be settled in state court.
You'd have to
As
exhaust
to
the
whether or not-
state remedy too under the younger doctrine.
We do.
You can't go directly to federal court.
You can't bring
And
it
as to whether-
in fact, I did it against
Wait a
the
minute,
sheer
let's try to be recognized if we'll speak. Okay.
It depends on if you have it would depend if you have a,
I sued Bashir on behalf of all the landlords and was successful under an 83 action. So
This isn't a landlord action. Okay, does council have anything else they wish to say?
I'd like to go ahead with this and in the hearing in 2 days.
All right, there's one.
I'm in agreement. I think we've drug this on long enough. She's
Me too.
had plenty of time to prepare.
Todd? Let's move forward.
I've had 2 days, guys.
Danny?
Well, I'd like to just make a little discussion. When we had the meeting a couple months ago, when the mayor asked if she could attend the meeting and bring her lawyer, you said yes. She didn't come to the council meeting. I mean, we have cameras where you can get online and see it, but she did not come, so she had ample time to talk to a lawyer because she asked if she could bring her lawyer. There was I don't know the proper terminology, she had to make a letter of her story to the Attorney General that, I think Alex at the meeting, you said Alex helped you. That got sent there, so her defense had been sent to the Attorney General's office when they asked for her side of the story. Am I right or wrong?
Okay, so you're saying you go ahead?
I say go ahead, because she's
That's
had
fine, I
no.
didn't have my attorney scheduled to be here.
So are you saying 2 days or continue?
I think they're saying 2 days.
2 days.
Okay, it sounds like the consensus is 2 days, so is there any further discussion?
So right now, you got a motion and a second
I do.
to the resolution as read.
Correct.
So okay, any further discussion would be appropriate.
Just a FYI, as our discussion yesterday, I cannot attend Thursday. So we discussed yesterday about doing Tuesday of next week or Monday, and I was okay with either one of those, but I cannot attend Thursday. I apologize, just, my wife cannot drive, she's still recovering from surgery, so it'll be about me present, just to.
The only thing that would be necessary for the certification of records, is that correct?
Right, we
You can have the court report.
And that could be done?
Yeah, we're gonna, but you can certify the records. Some of them are ordinances, so I don't think it would really,
Yeah, I got you, yeah.
you don't have to certify.
Further discussion?
I'd like the public to make any comments. Vicki? Yes. Take your mask off with me.
We're not supposed to be receiving evidence.
I think you got a motion and a second, and discussion among council, I don't think there's public
There's
input.
nothing about.
Any further discussion on the resolution? All right. Sean, call the roll.
So roll call, Humphrey,
Yes.
Duzing,
Yes.
Purcell,
Yes.
Martin,
Yes.
Roberts,
Yes.
Lowry.
Yes.
Motion carried.
There being no further business, is there a motion to adjourn?
I'll make a
Vicki,
motion.
the public has a chance to speak. Vicki, you
Only
had
if it's
something you want to
not-
say?
Only if it's not evidence.
Well,
Not now, it's not, okay,
she,
not now. So we'll move motion to adjourn here.
Is there a motion?
I got a
I'll make a motion.
I'll second it.
Those in favor?
Aye.
That makes sense, yeah. Okay. I got a fast pen, but I.
Oh, sorry.
Sean, I need the resolution as a copy.
I have the email. I got it on my file. Is that version of it all?
I'll take a motion to bring.
Yeah, I've got it all. Alex, this is your-
I cannot talk to you.
The wrong person.
I cannot talk to you.
Well, before you call the sheriff, make sure you know who it is you're calling on.
Thank you.